Hey guys, what's up? It's Andy here, and today we're going to be talking about dismissals. So I called it firing in the thumbnail, but traditionally it's much better to call it a dismissal. It's just better practice. I got some very good help today from Labourwise. They were kind enough to share some information. I actually got to sit with the managing director who deals with this kind of stuff every day. So if you guys like this kind of content, make sure to like and subscribe, and hopefully I'll be able to help some of you out there today. Jumping into it, the first thing that you want to think about if you are dismissing an employee is not actually to think about the dismissal. Yes, there are some procedures that we're going to have to follow, and that is all set out, but it's actually a little bit more important to think about it from the start of the process, and that is generally with relations to the contract. So let's hear a little bit more about that.
Yes, good morning, Andrew, and thanks for inviting me on the show. Yes, I think small businesses in particular tend to make the mistakes up front and then they pay the price for it later. So I think everything starts with the recruitment process. Don't just take anyone on without first doing some kind of a background check, a reference check. Also, consider what you're appointing them for, and let them go through some kind of exercise to determine whether they fit to do the job. If necessary, get somebody else to sit in. You know, people have different perspectives.
That right there, the perspectives, that's one thing that I really can't emphasize enough. It's something in my personal history that I've always had so much success with, is just getting, don't make it a you hiring thing. It's like you have a team at this point, and try get as many other people to input on that decision besides yourself. It makes the world of difference.
But getting the right person for the right position is absolutely key. I've seen on many occasions people appointing someone, and then about a month or so later they say, well, no, this person said they had this CV, they had this experience, they can do that, and they completely incapable. Or it's just come out that they actually left under a cloud. They were found stealing. In fact, they've taken their previous employer to the CCMA, and there was a settlement there. And despite the fact that they were dishonest and so on, how do we get rid of this person? So spare yourself the trouble. Go do a bit more homework before you appoint someone.
Interjection. I know this video is about firing people and dismissing people, but I am a strong believer in keeping your staff like a family. Keep them close, keep them as people that you want to be with every day, because you probably are with them every day. So yeah, even though I've made this video about the dismissal process, it is informative, and just so that you guys know where my beliefs are, it's like keep your team small, keep your team close, and if you do have to go through something, hopefully this video will help.
Then the second mistake employers make is with the contract of employment. Strictly speaking, you do not even have to have a contract of employment. The Basic Conditions of Employment Act says that the employer must provide an employee with written particulars of employment. And then there are a number of things that are spelled out, you know, the nature of the job, their working hours, their leave, and a number of other things. Typically the kind of things that you will find in a contract of employment. So even though the Act doesn't require you to have a written and signed contract of employment, it's good practice to have one, because then the parties know where they stand with each other. But then again, you know, online you might find these lengthy contracts of employment, really bulky things, and you read them and it has this Latin terminology in it, and you might feel quite chuffed if you've got someone who signed this, but nobody reads it properly and nobody understands it properly. And often it's more a burden than anything else. There are a few key issues that need to go into a contract of employment. And very importantly, you need to understand what the law actually says. For example, what are normal working hours? If you say 40 working hours in your contract and you assume that after that it's overtime, it means you have to pay overtime after 40 hours, whereas the Basic Conditions of Employment Act says normal working hours are 45. So if you understand that, then you know you only need to pay overtime pay after 45 hours. Things like that. People also feel they have to write into the contract when somebody starts and when they finish, their hours of work, and they don't build in any flexibility. Now, that's an important thing. You might decide, oh, no, we starting earlier. We want to start at 7:30, but the contract says 8, and the employee doesn't want to agree.
Yeah.
So it's a good thing to build in that kind of flexibility, which you can only do up front. Later it's a problem if you want to change things. And also keep things simple. Don't write in anything more than you need to. Also understand what it means, what a meal interval means. You need to know that you don't have to pay for a meal interval. You also need to know that a meal interval has to be an hour, but you can agree to reduce it to 30 minutes. Things like that. Not very complicated things, but if you're a new business, you wouldn't know these things. And it's just a good thing to get advice up front. Have simple contracts that are flexible. Also understand what the national minimum wage is, that it's linked to hours, not necessarily that you need to pay a minimum monthly wage. You can have somebody who works 30 hours a week and not 45 hours, and they're going to be paid proportionately less. I'm not saying that you need to stick to the minimum wage and pay people the absolute minimum, but it's good to just understand the parameters up front. Then you also need to understand which industry you're in, because you might fall under the Basic Conditions of Employment Act, but there are deviations from that. You have sectoral determinations. As you know, there's one for farm work, one for domestic workers. There's one for the security industry. There's the wholesale and retail industry, the hospitality industry, and they all have their own little permutations. Not massive changes, but there are some things that are different to the Basic Conditions of Employment Act. Then you also have bargaining councils, which are different to sectoral determinations, like the steel and engineering industry, for example, or the building industry. Understand those things up front, because that's the kind of thing that needs to be covered in your contract of employment. So you might as well get that right from the outset. Things like leave, for example. I've seen on so many occasions that people give people 21 working days leave, whereas the Basic Conditions of Employment Act is 21 consecutive days. So that converts to 15 working days per year, and employers don't understand that.
Just to explain that a little bit more, so it's 21 consecutive being the key word there. If you take a Friday and a Monday, that actually means 4 consecutive days as opposed to 2 days. 21 consecutive days generally works out to 15 working days. Important to distinguish between these consecutive days and days.
Not that you shouldn't give someone more. I mean, sure, if you want to give them 20 or 25 working days leave per year, well, then so be it. But at least understand that your obligation is not to give so much leave.
Let me know your thoughts down in the comments below about the 4-day working week that they're trialing in the UK at the moment.
So that's as far as the... Yes, Andrew.
What happens when it comes down to, let's say you had a reasonably firm contract in place and you're looking to dismiss someone? Is there a general procedure that that they can follow for, especially relating to small business?
Yes, there is indeed, Andrew, and that's where there's also a lot of misunderstanding, because you will find in every contract of employment and in the Act, Basic Conditions of Employment Act, it refers to termination notices. Like in the first 6 months of employment, you can give 1 week's notice. between 6 months and a year, it's 2 weeks notice. And after a year, it's 4 weeks notice. And employers read that and they say, well, that's what's in the act. And they give employees notice and they don't follow any procedure before dismissing the employee. Now, that's completely wrong. And people say, but that's what the act says. Surely I'm just following the law by giving the person notice. What they don't know is that there's also the Labour Relations Act, which prescribes certain procedures that you need to follow before terminating employment or dismissing a person. And there are also different reasons for dismissing. So it could be for misconduct, continuously coming late, being on a final written warning and so on, or stealing or assaulting someone. But you can't just dismiss somebody because you saw them on a camera stealing. You still have to follow a procedure.
Now, I think this procedure is precisely the point of the video. If you find yourself in a situation, like say you find someone stealing, you don't know how to react, because on the one hand you want to say, okay, do you tell them no, don't come into work, don't do this, don't do that, but then it's like on the back of your mind you're like, am I going to actually do more damage to your business because of possible backlash from the CCMA if you handle it incorrectly? So I think this is exactly where something like Labourwise could come in handy, is just to have that hot number, that speed dial number, and then you can just call and be like, okay, what do I do step by step? Because in those times you don't have a long time to act. You want to act quick and you want to act decisively, but you also want to know what you're doing. And if you're like me, you're not always an expert in like human resources. So yeah, I just think this is one of those key moments where this would be super useful.
And that procedure is prescribed in a code of good practice, which is part of the Labour Relations Act. It says that you have to give proper notice, you need to describe the misconduct, you need to give for the employee an opportunity to be represented by a fellow employee, you need to give the employee an opportunity to state his or her case. So you have to have some kind of a hearing. If you don't do that, then you could have the best reason for dismissing a person, but you haven't followed the procedure. If you're taken to the CCMA, you're going to fall short and you're going to have to pay compensation. But then there's not only misconduct. If somebody doesn't perform properly, they're just incapable of doing their job, there's a different procedure that you need to follow. If somebody has a medical condition, there's yet another procedure that you need to follow, involving also medical reports and so on. And then finally, there's retrenchment. If you have operational reasons, you want to reduce the size of your company, or some position has become redundant, there's a different procedure, quite an onerous procedure. And employers need to know that, so they can't just rely on what the contract says. Another very typical mistake that employers make is they say, well, in that case, what I'll do is I'll employ the person as a casual, or on a month-to-month basis. I'm not going to let them sign any contract. They're going to be working for me on a month-to-month basis. Now, the problem with that is that whether you have a document or not, as soon as the person starts working for you and gets paid for working for you, they're regarded as an employee who's been indefinitely employed. In other words, permanently employed. You can call them a casual if you want to, but they're not going to be seen as a casual or a monthly worker. They're not going to be seen as a monthly worker. If they take you to the CCMA, told them to go, there is a good chance they're going to be reinstated, and with retrospective effect, which is going to hit your pocket hard, and I think it's going to hit your pride even harder. So it can be a very painful thing if you end up in that situation. Another mistake that employers make is that appoint somebody on a fixed term contract because they want to see how well they're going to be doing before giving them a permanent contract. Now, that's then a substitute for probation. So you cannot put somebody on a fixed term contract if you want to assess their suitability. You have to put them on probation. In other words, appoint them permanently, but subject to probation. And even with probation, there's a process that you have to follow before dismissing. You first have to counsel and guide, and you have to have something on record, which is another mistake people make. Oh, we discussed it many times. Where do you have it? No, we discussed. When did you discuss? Oh, yeah, when was it again? But, there's just nothing on record. So you need to have something on record. At some stage during the probationary period, you need to have on record that this is the end. If you don't, there must be some kind of ultimatum. If you don't meet the standard by a certain date, then we will have to look at terminating your employment. And you have to have that in writing. It can be in an email, it can be in a memo or something, or even in an audio recording, but something like that, some record. So that's a major mistake that people make. The other is, let's say it has nothing to do with probation, but they just put people on fixed term contracts for, let's say, 6 months or a year, and then inform the person that if they don't like them, they don't like the way they perform, or any other reason, they just inform the employee that the contract has now come to an end. But there is no reason why it should be a fixed term contract. So what the law says, this actually came into effect in 2050, is that you must have a justifiable reason for a fixed term contract. And that justifiable reason must be written into the contract.
At the beginning.
If it's not written into the contract and you have a good reason and you terminate, it's going to be seen as an unfair dismissal.
Wow.
And that employee can be reinstated with retrospective effect. So you've got to get it right. It's not rocket science. It's not very complicated, but you're not necessarily going to know it up front. And employers should just get the right advice from the beginning, and they won't make these mistakes.
But yeah, that actually brings me to my last question is, I know Labourwise has been quite pronounced in the industry of sort of online human resources management. It used to be, I think back in the day, you'd have to hire your very own human resources manager into your company to be able to get access to information like this. But how has Labourwise fit into the picture for small businesses?
Andrew, we actually aim primarily at small and medium-sized businesses, those that don't have their own human resources manager, although we have many clients that have their human resources manager and make use of our services, because we also have the legal angle. We look at labor law and employment law. So that's where we can supplement or assist human resources managers. But primarily, I'd say it's small and medium-sized businesses, where often the accountant ends up having to do the HR. And we all know that accountants are accountants because they're not necessarily people person. They work with figures, but they're the ones that deal with the payroll. So those would typically be our clients. The guy who either has an accountant or doesn't even have an accountant. He's the accountant who does everything, or she runs her own business. And that's where we come in, providing simple solutions to small and medium-sized businesses. We can provide them with resources, but we also available online. So they suddenly have an issue at work, they just pick up the phone and call us, or they pop us an email and we give them a call back, respond to the email, or a combination of those things. So it's like an immediately available resource to help with the day-to-day HR, labor law, labor relations issues.
Perfect. I mean, I've personally been in a few tricky labor situations where, especially as a small business, it's like you almost become family with people, and it becomes a very emotional thing actually to deal with it, and to quickly now to find advice when it, you in retrospect, you're like, oh, when it happens, you'll just find someone to reach out to. But then when it happens, you panic and you don't have that lifeline there. And it's nice to have someone that you can just pick up the phone and be like, okay, I'm dealing with this. What do I do? And it's not an expensive service from what I've historically seen about Labourwise. So yeah, hopefully, it'll help some small business out there. Jan, thank you so much for giving your time today. I think the amount of information we learned today is invaluable to a lot of the small businesses out there. It's a difficult area to talk about because it is quite in depth, and I think hopefully we'll be able to get you back on to dive into a few other things that I'd still love to talk about. So yeah, Jan, thank you to yourself and Labourwise for giving your time.
Okay, it's a pleasure, Andrew.
All right, you legends that made it all the way to the end. That was Jan Truter from Labourwise, and he is the managing director there. As you can see, he has a wealth of knowledge that he shared with us today, and it is so awesome to get it straight from the experts to us. And if you guys like this type of content, you're starting a business, you want to grow your business, make sure to like and subscribe, and I'll hopefully see you guys soon.